Yes, sir.
Okay, we're on the record in Brink versus Hildebrandt, case number 11145050. The record should reflect Ms. Brink is present today by Zoom video. Ms. Krause, can you tell me the status of this file today?
This hearing was adjourned from August 5th to allow the plaintiff to obtain friend of the court forms regarding disability and complete and submit them back before today's hearing. No information has been received regarding her inability to work. The only contact the office has had with the plaintiff is on August 12th when she dropped off a letter requesting to sign off her rights to the child and support to stop. Friend of the court staff did indicate she may need to reach out to probate court to move forward regarding that information.
Right from the opening, we're dropped into Brink versus Hildebrandt. The judge sets the scene, but within seconds the focus shifts. Miss Brink hasn't filed her disability forms, and worse, she's asking to sign away her parental rights. No mention of working toward custody, no fight for the kids, just a request to be done with them entirely. Question for you. If you were the judge, would you see this as a desperate plea or a shocking abdication of responsibility?
And outside of that, the plaintiff has a support obligation of $197 and a balance of $8,709.16. The last payment was received in February in the amount of $206.47 from a prior income withholding.
Okay, Ms. Brink, why did you not submit those forms as you were ordered to at the last hearing?
I never received them.
Okay.
They were supposed to have been mailed to me.
Did you go in to get the forms?
They were supposed to have been mailed to me. That's why I provided my address at the last court hearing.
Okay. Did you do anything to follow up with that at all?
I mean, it's not really my responsibility when someone doesn't do their job.
Well, it's your responsibility to pay your child support payments, and if you don't pay
But that has nothing to do with the disability paperwork.
Okay, I'm not going to argue with you. We went through this. Yeah, you are, and we went through this at the last hearing. We confirmed your address. We told you
so that they could be mailed to me, which they were not.
They were mailed
and I would like to sign off my rights to my children. And Devin said that he would not fight it. Bill did not fight it. He came and he signed. And when it came time for Devin to sign, he didn't show up. And I have a text message saying that he doesn't want, or that he wouldn't fight me on signing off my rights to Lila or John. So I'm not sure why he didn't sign the paperwork.
So you still are the parent and you still owe the child support.
But I'm requesting the court to terminate my rights to my children.
The tension builds as Miss Brink insists it's not her responsibility to follow up on missing forms, even when those forms could help her case. She pivots quickly, claiming her ex agreed not to fight her on giving up rights, but then didn't show up to sign. Her logic? If the other parent didn't cooperate, she's off the hook. The judge's face says it all. This is not how the law works. Observation. It's a masterclass.
She has a stepmom that can adopt her. I don't want anything to...
Buckle up, guys. Today, we're diving into a case that's as jaw-dropping as it is heartbreaking. A woman walks into court not to fight for custody, but to give it up entirely. What's worse? She's broke, homeless, and clearly spiraling. This intro lays the groundwork for what becomes a raw unraveling of a life in freefall. It's not just about court orders, this is about consequences, lost control, and a system forced to...
Well, there's a process for that, and that process hasn't occurred yet, which means...
Okay, well, I've asked for that process to be started a year ago. This is the second time I'm bringing it up.
Okay, well, you have to do more than just ask. It's up to you to...
well, that's why I had the document written up and by an attorney, and so that Devin would sign the paperwork, and he said he wouldn't fight me, and then he didn't show up to sign it. So I don't understand what the big problem is.
Okay, so how are we going to deal with you paying your child support till that happens then?
I don't know. I have a paycheck coming from Boyne River, and you can have that. Okay. But other than that, I have $34 to my name. My house is for sale and I'm living in my car.
When are you getting that paycheck?
I don't know. It should be garnished. I probably won't even get a paycheck. It should be garnished by child support.
Do we have an income withholding, Ms. Kraus, for any employers with Ms. Brink?
There is a potential income withholding.
Now the cracks widen. Miss Brink admits she's broke, living in her car, and has $34 to her name. But instead of a plan to regain stability, she floats the paycheck she might get. The problem? That job is already gone. She was fired because the bartender didn't like her. Engagement prompt. Is this bad luck, bad choices,
But it wasn't
or both?
reported, so outside of her indicating where she's employed today, that process could take 6 to 8 weeks. So I can't guarantee that monies would be withheld from that paycheck.
Yeah, it should be. I've never had a problem with it not being withheld in the past.
Okay, well, we don't have the information from your employer, right? Ms. Kraus, is that what you're saying?
Yes,
She's
you
never...
do.
Correct.
They reported it.
Hold on, Ms. Brink. Ms. Kraus?
An income withholding was sent, but until monies are withheld, we wouldn't be able to indicate if that amount would be withheld. But the employer was not reported. It's pending, so I can't guarantee that the employer received anything.
They did.
Okay.
They told me.
Well, we haven't received any money from them, so apparently they haven't.
I haven't gotten the check yet. I haven't even been. I get paid every 2 weeks, and I've already lost the job. They already fired me.
So you're not employed. You're not employed, is what you're saying.
Not currently, no. I lost the job. I got fired. The bartender didn't like me.
Okay. What about the disability? Where are you at with that?
I filled out all the forms that they requested from me and mailed them back in the timeline that they gave me. But I'm living in my car, so I don't have access to my mailbox anymore. So I have to contact disability today after I get off the phone after I get out of court and report my address to be at my parents' house. There's no guarantee that they're going to tell me that the disability paperwork comes. I'm going to have to, I don't know what I'm going to do because I don't have gas to get to their house.
Homeless, unemployed, and estranged from her own parents, who've blocked her number, Miss Brink says she can't even receive mail for her disability paperwork. The judge listens, but the patience in the room is wearing thin. By now, the high story isn't just about missed payments, it's about a complete breakdown of stability, observation. This is where the court begins mentally preparing for the inevitable contempt
And they have
ruling.
me blocked on the telephone.
Right from the jump, the courtroom is hit with a shockwave. The defendant casually says she wants to give up her rights to her own kids. The judge doesn't flinch. He reminds her, parental rights aren't hers to terminate. It's a legal bombshell, but also a tragic glimpse into just how broken things have become, her detachment, chilling, her logic. Alarming, and the courtroom starts tightening its grip from here.
Your Honor.
Okay. Yeah, go ahead, Ms. Kraus.
In regards to her being homeless, she may be able to reach out to the local post office. They may have something for her in regards to obtaining a P.O. box, but she would need to check further into that.
Well, I don't have money to pay for a P.O. box.
They may have some options for you regarding if you're homeless right now. I don't know the details in regards to that, but it is some information that friend of the court has received in regarding post offices when people are homeless.
Okay, I'll look into that.
All right, well, here's Ms. Kraus, has there been, how many findings of contempt has there been in this case on Ms. Brink?
This would be a first finding.
Okay. All right, so Ms. Brink,
I'm not in contempt, Your Honor. I have no problem paying it. It's just I can't get a job because I have felonies. No one wants to hire me.
I do
I've already put out more applications. I'm not in contempt, though. I have no problem paying. It's just that I can't get a job. No one wants to hire me.
You are in contempt, first of all. I find specifically that you are in contempt because you aren't doing any of the things that I ordered you to do the last time, and you can't just
Your
say,
Honor,
well,
like what?
like fill out the forms for your disability.
They weren't mailed to me. How can I fill out forms that weren't mailed to me?
I'm not going to
I
argue
called
about.
and asked.
Okay,
I called and asked.
Now I'm finding you in contempt for continuing to interrupt me during this court hearing and inhibiting the court's ability to conduct this hearing. You're continuing to talk over me. I'm trying to explain to you.
I asked you a question.
You just told me that you're not getting mail at your parents, and there's no guarantee that you're going to get your mail. So how do you know that you didn't get this? We sent it to the address that you gave us.
And I was living there up until Friday.
It's not my problem that you aren't getting your mail. All we can do is
getting my mail.
Obviously, you're not
making sense, Your Honor.
All we can do is send it to you at the address that you give us.
And you didn't.
It's up to you. So you haven't followed through with what you were required to do.
Yes, I did. I called the child support office and asked about it, and they said it was too soon for me to be calling.
I'm going to mute you now so that I can say what I need to say for the record here, because you're continuing to talk over me, and I'm not able to conduct this hearing. So the court adjourned the previous hearing in August to give you an opportunity to submit the forms that were required to be submitted. That's your responsibility to make sure that that's done. We had this colloquy the last time about your address. You gave us an address. That's the address we've been using. If you haven't received the mail, that's between you and the post office and you and whatever is going on with the address that you gave us. All we can do is send out forms. If you didn't get them in the mail, then it was your responsibility to contact the friend of the court, go to the friend of the court, make arrangements to get those forms and fill them out. But that's squarely your responsibility. It's your responsibility to pay child support for your child. That's still your child. Your parental rights haven't been terminated. As far as I can tell, you haven't done anything other than say you want that to happen to make that happen. So you haven't paid child support. You haven't complied with any efforts of the friend of the court to give you options outside of paying child support. So the court finds that you are in contempt because this would be a first finding of contempt. The court finds that you should be sentenced to 45 days in the Otsego County Jail. The court is going to order that you turn yourself in to the Otsego County Jail by 5 p.m. today. That's September 3rd, 2024, to begin serving the 45-day sentence. If you fail to turn yourself in to the Otsego County Jail by 5 p.m. today, then the court will issue
the breaking point. She interrupts the judge repeatedly, challenges the court's findings, and claims she's not in contempt. The judge has had enough, finding her in contempt, sentencing her to 45 days in county jail, and ordering her to turn herself in by 5 p.m. that same day. Question: do you think jail time will push her toward compliance or just deepen the spiral?
For your arrest. Ms. Krause, if you can prepare an order to reflect the ruling of the court on that today.
Yes.
All right. That's all for this hearing today. The court's going to disconnect from this brink.
Now things start getting ugly. She tells the court she's living in her car, fired because the bartender didn't like her, and has a grand total of $34 to her name. The judge, not buying excuses, drops one of the most brutal lines we've heard. Your parents blocked your number because they can't stand your ass. This isn't just legal, it's personal, raw, and dripping with tension. The system has lost its patience, and so has everyone around her.
Yes, sir.
All right, we're on the record in Brink versus Hildebrand, case number 11-14050. The record should reflect Mr. Hildebrand is present today by Zoom video. Ms. Brink has not appeared today. This hearing was set for 9 a.m. It's now 9:26. She is not present. Ms. Krause, can you tell me the status of this case today, please?
The plaintiff has a support obligation of $197, and the total amount due is $9,715.16, which includes this month's obligation. There has been no payment since the last hearing when the plaintiff was found in contempt and served 45 days in the Otsego County Jail and was released on October 9th. The last payment that was received was from a prior income withholding in the amount of $206.47 in February of this of 2024. There has been no communication with the plaintiff.
Ms. Kraus, I saw you kind of nodding your head. Was there anything that you wanted to add to this?
Yes, it is brought to my attention that the plaintiff is actually in Otsego County Jail as of yesterday. I didn't check the inmate list this morning. I apologize.
All right. In terms of going forward, although we do have that additional information, the court's going to issue a bench warrant for Ms. Brink. Since we do have her lodged already, Ms. Kraus, I think what we'll try to do is set that for a arraignment hearing on Wednesday when I have my criminal docket. Mr. Hildebrand, did you want to be present for that?
Yeah, please, if I could.
Okay. When we get the date and time of that, we can contact you. Ms. Kraus, do you have Mr. Hildebrand's contact information?
Yes, we should.
Okay. So Mr. Hildebrand, we'll let you know the date and time, but I'm going to try and get that on the docket for Wednesday at some point, and you can join by Zoom as you're doing today.
Fast forward. A new hearing begins, but Miss Brink is a no-show. The twist? She's already in jail. Again. The judge cancels the bench warrant since she never actually left custody. It's a rare courtroom moment where the system's gears are turning faster than the defendant's ability to keep up.
All right. Thank you. Yes, sir.
Okay. All right. Thank you. You're free to disconnect at this time, Mr. Hildebrand.
All right. Have a good day.
Okay, Mr. Brown, you were set for here. You were asked to appear for this hearing today. I don't know if we're going to need you or not, but if you don't mind just staying connected just in case.
Sure.
Okay, thank you. So what we're on the record for, again, this is Brink versus Hildebrand. This is file number 111400. This was set for a hearing today. It was originally on the court's Monday show cause docket. Ms. Brink, you were ordered to appear before the court to show cause for non-payment of child support. We discovered during the course of that hearing that you had already that the reason why you weren't appearing for that on Monday was because you were already lodged in the Otsego County Jail on a different charge. So the court then set this for a hearing today. So in terms of the non-payment of child support, the court isn't going to proceed on the contempt for your failure to appear because I'm satisfied that you couldn't based on your incarceration. So the court's just going to proceed on the non-payment of support issue. And so Ms. Kraus, can you tell me the current status of the account and what friend of the court is asking the court to do in terms of the non-payment of support issue?
Yes, the plaintiff has a support obligation of $197. The total amount due is $9,715.16, which includes this month's obligation. There has been no payment since February of 2024. That amount was $206.47. Since the last hearing, the plaintiff was found in contempt and served 45 days in the Otsego County Jail and was released on October 9th. And then we would be requesting to further address contempt as the plaintiff has not exercised any due diligence regarding payment or contact her since her release from jail.
All right, thank you. Mr. Hildebrand, was there anything that you wanted to say in regards to this matter?
Not today, sir.
All right, thank you. Ms. Brink, can you address your non-payment of support between the last hearing and now?
Just the only thing I really want to say is that when I get out of jail, I'm going to sell my house and move in with my my church lady, my church friend, and when I sell it, it should be enough to cover the total amount due. So that's my plan, to pay it.
This is the moment where it all breaks wide open. The judge, fed up with the constant dodging, finds her in contempt of court and orders 45 days in jail effective immediately. There's no more back and forth, no more negotiating. This isn't Just a courtroom scene, it's the law hitting full force. And with a single gavel strike, her freedom disappears. It's the turning.
Miss Brink promises that when she's out of jail, she'll sell her fully paid-off home to cover her child's support debt. The court agrees to revisit the matter in February, but after so many missed obligations, the judge and the audience both. No. Words are easy, action is rare. Engagement prompt. Do you believe she'll follow through, or is this just another
Point
delay
you feel in your gut.
All right.
I don't have any way of paying it as of now because I'm jobless.
What's the status of your?
Disability has denied me.
What's the status of your current charges there that you're lodged
I
on?
have not. I've been served the paperwork, but I have not been arraigned on it. I get arraigned on it on the 13th.
Okay. Do you anticipate that you're going to be posting bond, or are you going to remain lodged? Okay. All right. Ms. Kraus, what I'm going to do is ask you to set this for another hearing in February. Obviously, if Ms. Brink is currently incarcerated and isn't released on bond, I don't think we can proceed with the contempt at this point if she's incarcerated by statute. So I'm going to ask that you set this for a hearing in February. If she's released by that point, then we'll proceed with the contempt hearing. If she's not released, then we'll determine what the next timeline will be. Okay.
Okay, and then in regards to the bench warrant then for this particular case?
The bench warrant is going to be recalled just because she's lodged. So we really can't proceed while she's incarcerated.
Thank you.
On collections, again, by statute. So we'll set it for February. If she's out in February, we'll proceed with enforcement. If she's not, then we'll set further scheduling from there.
Okay.
Right. Mr. Hildebrand, do you have any questions about how we're going to go forward?
No, pretty much just wait until she gets her legal stuff squared away, and then we're going to go from there, correct?
Yeah, exactly.
Okay.
Ms. Brink, do you have any questions at all?
No, sir.
Okay, thank you. That's all for this hearing today. All parties on this case can disconnect at this time.
Thank you.
Yeah.
Our next hearing is set.
All right. Is that you, Ms. Brink, at the county jail?
Yes, sir.
All right, thank you. We're going to call your name, your case next, so let me find that on the docket here. All right, we'll call People versus Chelsea Brink. That's 25-43389-SM.
John Blair Brown on behalf of Ms. Brink.
All right, looks like we're here for it. I'm sorry, Ms. Brooker, go ahead.
Go ahead. Amanda Brooker appearing on behalf of People.
Thank you. Looks like we're here for a jury status conference. Do we have a resolution, Mr. Brown?
Your Honor, I don't believe there has been an offer in this matter. I'll defer to Ms. Brooker in case there has.
There's not an offer.
This is a simple assault, Your Honor. I believe I sent something to the court on this matter. It is my understanding that Ms. Brink, if it is acceptable, will be entering a no contest plea for any potential civil liability.
I do see an affidavit of probable cause, but I do not see any other documentation that may have been sent to the court today. Is there something specific that you think you sent, Mr. Brown?
That is.
I sent 2 pages that I believe.
Yep, I do see that now. Yep, I do see
what I sent.
All right, I just didn't know if there was something else specific that you had. So I have received those 2 items. All right, Ms. Brink, your attorney has said that he believes that you wish to enter a plea to the charge of assault and battery and plead guilty as charged. Is that what you want? Excuse me, plead no contest as charged. Is that what you want to do today?
Yes, sir.
All right. If you do that, you would be giving up your trial rights and you would not have a trial because you'd be telling me that you did something that was against the law. Do you understand that?
Yes, sir.
If you had a trial, you would have certain rights. So I want to tell you what those rights are so that you can make an informed decision. You have the right to have a trial by a judge or by a jury. You have the right to have the assistance of an attorney at that trial. You have the right to see, hear, and question the witnesses against you at trial. You have the right to call witnesses on your behalf and to get an order called a subpoena to require those witnesses to appear and testify on your behalf. You have the right to be a witness yourself or to remain silent. And if you choose to remain silent, that silence cannot be used against you because you have an absolute right against self-incrimination. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Do you understand each of the rights that I've just read to you?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Do you understand that if you enter a plea today, that you would be giving up, waiving, and not having any of those rights, other than you would continue to have Mr. Brown as your attorney?
Okay.
All right. Would you raise your right hand, please, so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can put your hand down. Has anybody promised you anything to get you to plead today other than what's been stated in court today?
No, sir.
Has anybody threatened you in any way to get you to plead guilty?
No, sir.
Now the case shifts. She's facing a criminal charge for assault and battery. The plea process is careful and methodical, with the judge making sure she's acting of her own free will. But in the middle of it all, she blurts out that the victim gave her a look, and that the cop arrested the wrong person. It's an awkward collision of legal procedure and personal grievance.
Are you doing so of your own free choice?
Well, kind of. Sean John Conrad, he gave me a look.
I'm sorry, who gave you a look?
Your Honor.
Sean John Conrad, he did.
When her name is called for another hearing, she's nowhere to be found. But the twist? She's already in jail. The judge starts prepping a warrant until they confirm she never left custody. It's a bizarre full-circle moment, the legal system keeping her right where it last left her. A hearing without a defendant turns into a realization that the system now fully owns her schedule.
How is that making you do
He peered
today?
over. Well, he peered over the cop's shoulders when I was, and during the course of the interaction, he reached for a knife, so I was intimidated and fearful of him.
Are you talking about at the time of the incident, or are you talking about today?
The time of the incident?
All right, I'm talking about today. Has anybody threatened you in any way to get you to plead guilty today?
Not today.
All right, is that time of the incident, are you telling me that you're acting today because you feel threatened today because of that previous incident?
In a way.
Well, here's the deal. If you're being threatened in any way, I'm not going to take a plea from you. You have to be doing this of your own free choice and free will. And if you're not, I'm simply not going to take a plea from you. I don't want anybody or you to feel like anybody is threatening you or doing anything that would take away your absolute choice in this matter. Do you understand that?
Sure.
All right. And now, in understanding that this is your choice and your choice alone, do you still feel that you're being threatened in any way to get you to plead guilty today?
I mean, I think the cop arrested the wrong person, but I don't feel like I'm being threatened necessarily, but I have nowhere to go if I'm let out of jail because Sean Don Conrady is still in my residence.
Well, we can deal with that later, but today is a day for whether or not you're going to plead. I can't solve all of your problems today. I just simply need to know that you're making this choice of your own free will and you're not feeling actively threatened today to make that plea. Is that true?
Okay.
That you're not being actively threatened today? All right.
Right.
Then I will go ahead and continue with the plea. If you change your mind at any time, you let me know, though, all right?
Okay. Thank
All right.
you.
So I'm going to ask you some questions about what you did. Is it true that on January the 5th of 2025, in Bagley Township of Otsego County, that you did make an assault or an assault and battery upon Sean Conrady?
Your Honor, this is a no contest.
I'm sorry, that's true. That's a no contest plea. I apologize, Mr. Brown. Thank you. And you have sent to me, Ms. Brink, do you agree that I can look at some paperwork to determine whether or not you made a plea, an assault, so that you don't have to admit responsibility to that? Is it okay with you if I look at the police report and the affidavit of probable cause? All right, thank you.
Yes, go ahead.
Thank you for bringing that to my attention, Mr. Brown. I appreciate that. All right, I do find from the affidavit of probable cause that Chelsea Brink assaulted or assaulted and battered Mr. Conradi by punching him in the side of the head and neck with her right hand, and that there was a small red mark on the side of his head, and that this was an incident involving being upset about a DVD player and an Xbox cord at the residence in Otsego County, specifically 1336 Groveland Avenue in Bagley Township, on or about January the 5th of 2025. I do believe that that satisfies the proper factual basis for the charge. Any other questions as to factual basis, Mr. Brown or Ms. Brucker?
No, Your Honor. I believe there's a factual basis.
And do you believe that we? Thank you, Mr. Brown. Do you believe that we've also complied with the court rule for taking pleas?
Yes, Your Honor. I'm sorry.
Yes, Judge.
All right, Ms. Brink, do you still want me to take your no contest plea?
Yes, sir.
And do you understand that a no contest plea, for all intents and purposes, is exactly the same as a guilty plea, except that I read the paperwork instead of talking to you about it? You understand that?
Yes, sir. Yes, sir.
All right. I will accept your plea. I do believe there's a proper factual basis, and I'll find that you did so knowingly, intelligently, and voluntarily. Let me catch up on my paperwork here. Mr. Brown, do you wish to proceed to sentencing right away?
I would like to, but I mean, there is a victim.
Probably can't without a victim.
I would have to defer to Ms. Brucker.
Judge, we have sent him some information. He doesn't have a working phone. We've not heard back from the information we've sent him. So if the court wishes to go forward, I don't have an objection to that. If the court wants to set it out for a week, I'm fine with that as well. And we can continue to attempt to get a hold of him.
I prefer to give him every opportunity to appear if he wants to do that. So let's set it out for 1 week. We'll come back on January the 30th at 1:30. Mr. Brown, do we need to address bond for your client, or are you satisfied the way it is?
Your Honor, I don't think we need to address it. She is actually sitting there on another child support matter as well. So regardless of bond, she is not going to be able to bond out.
All right. Ms. Brink, you understand that?
Yes, sir.
All right. So we'll be back in a week.
Her no contest plea is accepted, but sentencing is delayed so the victim can be heard. Regardless of the bond discussion, it's clear Miss Brink isn't going anywhere. She's still held on child support matters, and her legal troubles are now running on two parallel tracks.
You'll be able to tell me your side of the story at that time, and I'll hear from Mr. Conradi if he wants to make a statement, and then I'll also hear from your attorney at that time as well. So we should be good to go. So I'll talk to you then.
Okay, thank you.
Even from jail, the chaos keeps building. She appears on video still owing child support, still with no payment, still with no plan. But then, a sliver of something unexpected, she claims she owns a paid-off house and might sell it to cover what she owes. The court agrees to wait. But this isn't hope, it's hesitation. Because after everything we've seen, promises like that mean nothing without action.
That's file 11-14050-DS. I do see Mr. Hildebrandt is here. Do we have Chelsea Brink with us?
Yes.
Could you put your video on, please, Ms. Brink?
I don't have that capability, sir.
Where are you at right now?
I'm here via phone.
Where are you physically located at right now?
The Comfort Inn and Suites. I got a room here last night. My dad gave me $1,000. Ouch.
What type of phone do you have that doesn't have video capability?
Galaxy something. It's an Android device.
All right. And you didn't download the Zoom app? You're just calling in?
No, I'm connected via phone. That's the best I can do, Your Honor.
All right. Ms. Kraus, is this your matter?
Yes, for this case with the Hildebrandt, yes.
All right. My order last time was that Ms. Brink submit documentation about job applications. She was supposed to do 10 job applications each week to the Otsego County Friend of the Court. Has she done that?
She has not. There was a voicemail that was left in regards to a couple concerns that were outside of employment issues that were outside the scope of Friend of the Court. That message was left for the other case manager.
That's the most untrue statement I've ever heard in my life. My voicemails were regarding job applications.
The final blow to her credibility. Ordered to submit 10 job applications a week. She hasn't done it. When confronted, she calls the court's statement the most untrue thing she's ever heard. The case ends without resolution. But the pattern is crystal clear. Delay, deflect, deny. Final take. This is a courtroom saga that blends personal collapse with legal consequence. It's not just about unpaid support. It's about a life unraveling in real time and a court running.
Ms. Brink, I will get to you in just a minute, but you don't get to just interrupt somebody else that's talking. I can't have a conversation with one person if somebody else is talking over that. You will have a chance to say what you need to
lies about me.
Ma'am, you will have a chance to say what you want to say in a minute, but I need to talk to people in order, and it's not your turn. If you're going to do that in the future, I'm going to require you to be here in court. And if you're going to be here in court, you're going to behave yourself just like you would when you're on the phone. You understand that? All right, Ms. Kraus, go ahead.
Yeah.
As to the voicemail and the contents, it would be more appropriate to speak to the other case manager. Her obligation is $197. The arrears for this specific case is $10,604.42. The only payment that's been received was a payment in April and May. $100 was received, but $49.37 was distributed to this specific case each month.
All right. I do see Mr. Hildebrandt is here as well. Mr. Hildebrandt, have you received any child support payments from Ms. Brink?
No, sir.
When was the last time you did?
I want to say it was in May, and it was like $45 or something.
All right.
I think I might have received 2 payments possibly. And
Same that was Ms. Kraus was just talking about?
Yes, sir.
All right. All right, Ms. Brink, please tell me why you have not done the 10 applications per week and submitted them to the Friend of the Court.
I've been in the hospital for the last month. You ordered it.
I ordered you to be in the hospital for last month?
Yes. The police came to my house and said they had an order from you saying to go to the hospital. So I went to the hospital with them.
Which hospital did you go to?
Well, they took me to Otsego Memorial Hospital emergency room and then transported me to D6 at Munson in Traverse City after that.
When were you released from the hospital?
For the entire month, but I did submit applications to a few places. I left a voicemail on Friend of the Court and the prosecuting attorney's voicemails saying that I did that. And I had a job interview at Taco Bell yesterday, but it's really just not. I'm in a ton of pain. I've been in 2 car accidents, and I'm homeless. So getting a job and making child support payments is not at the top of my priority list, although I know it is at the top of yours because my children need support, but I just can't right now. And I apologize for that, but there's just really nothing I can do. I don't know what to do. Nowhere seems to be hiring. I'm doing the best I can, to be honest with you.